welcome to Crime in Court. My name is Heather, and this is an update in the Sarah Boone case. So, Sarah Boone is currently charged with the homicide of her boyfriend. She put him in a suitcase, or somehow he got into a suitcase, and she says she left him there. She says they were playing hide and seek. Um, but there's some nasty video of her yelling and swearing at him while he's in there, and he's begging to her saying, Sarah, I can't breathe. And she's just laughing at him. So it doesn't look good for Sarah. Sarah is now on her eighth public defender. She has somehow gotten all of her attorneys to either, excuse me one second. Sorry, I had a cough. Um, So she has either gotten them to withdraw from her case, or they've just gotten so fed up with her and they just wash their hands of her or whatever. They've claimed, irreconcilable differences. So she's on the eighth court-appointed public defender, and she's also very famous for writing letters to Judge Cranick. So this is addressed from June 7th. This is her latest letter to to the Honorable Judge Michael Cranick in Orlando, Florida, from Sarah Boone in her with her inmate number and everything. You guys could write her if you want. I wouldn't want to be her pen pal though. You'd be busy for a while. All right, so Honorable Judge Cranick, ongoing 5 years. Why can't I dot 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 use my constitutional rights? Am I the only one who cares about the ongoing violations of? Why can't I have a bond? Have all my medical records, have all my digital evidence and discovery, have all my paperwork, notes, letters, pictures, everything of mine returned by former attorneys? Why can't I speak to my investigator? Have a complete download of my phone? Have any of my witness lists? Give any insight, understanding, clarification, truths about my case, especially to my attorney? Be listened to by anyone, especially my attorney? Be respected for who I am truly, for who I am truly, especially by my attorney, and not be disrespected for the mutated, malicious M word all the world has falsely, incorrectly created and believes me to be. Okay, that's a little interesting, flowery language from Sarah Boone. We know she likes to keep us interested, so what else does she have to say? The mutated, malicious M word. I don't want to say to get stricken by YouTube. All the world has falsely, incorrectly created and believes me to be. I mean, she has every right for a fair trial and to be considered innocent until proven guilty. However, she spoke way too much to law enforcement, and we've seen all the body cam footage and the interrogations also. And um, she shouldn't have spoken to cops. That's why you don't speak to cops. But anyways, um, so her story was when the officer showed up at her apartment, it was she was playing hide and seek with him. She went to bed and thought he'd be back up soon and just left him there and fell asleep. And then in the morning she woke up and went, "Oh my God, where is he? He's still in the suitcase." And at that point, he was no longer breathing. And that's her story. And it's been pretty public, because we've seen the body cams. But whatever. Someone has painted her as this mutated, malicious M word. All right. Be treated fairly, lawfully, and be protected by the justice system. I agree that there's a lot of injustice in the justice system. So I try to give her the benefit of the doubt, okay? Even though, I mean, even if she did do the things that she's being accused of purposefully and maliciously and intentionally, even if she did those things, she still has a right to a lawyer. She still has a right to to remain silent and not speak to law enforcement, but she gave that right, or she waived that right. Um, she has a right to all sorts of things. Her going into a trial, the defendant's rights are the most important and should be protected utmost before anything else because you don't want to give that person an unfair trial. You don't want somehow for the scales of justice to be tilted in another way, and then it's not fair. So there's supposed to be the scales of justice, and whether that's happening or not, you don't know. Anyways, I don't think there's a lot of fairness in the justice system today. So I'm trying to see her with the benefit of the doubt. If she is really requesting a lot of these things or has requested them at some point and has never received them, I get, she'd be upset. However, the judge isn't going to be able to do anything for her because all this does is put it on the record that she wrote the judge, but the judge isn't going to write her back. The judge isn't going to correct any of these things. So it's unfortunate that you can't even write the judge in your case a letter, and like there's no recourse if your attorney isn't. And I'm not saying that her attorney, this eighth attorney, is in the wrong at all. But I'm saying if you and your attorney don't get along or there's something going on that, you're butting heads about, why can't you? There's no one to seek above them. There's no boss that you can go to. It's not like the business world where people keep other people accountable. And this is why power becomes corrupt because no one's keeping other people accountable in these positions of power. But anyway, I digress. Sorry. Sarah wants to know why she can't properly, rightfully, completely defend herself, see all and know the same as the world can and does, including my attorney, from all the phenomenal, non permissive amount of my entire case being available online globally before my trial, and most important, before I have even seen it myself. Why doesn't anyone know already about my case? Or what doesn't any, sorry, I read that wrong. What doesn't anyone know already about my case? See? Because she spoke to the police. She never talked to the police. This is a perfect example of why you don't. Just say, oh, I got in there. And then you talk to your lawyer. Want my lawyer. And then you deal with it then. You and then your lawyer can fight for your rights and try to give you the least amount of punishment for the crime. They're not going to get you off scot free necessarily, but they can help mitigate. If you did the crime, then they can help regulate between and be a mediator. But if you are not admitting to doing the crime, or if you're a total narcissist, or I'm not saying she is, but I'm just saying, um if you aren't cooperating with your attorney and you're just being difficult to be difficult, then that's an issue. All right, so she also wants to know, um how about my side in everything about everything. How about your side in everything about everything, Sarah? Tell us, please. Oh, wait. This is a 58-page letter where she's going to. All right, so why can't she be correctly understood that I am not the problem for reasons I am on malappointed by the court attorney number 8. See my letter from 7/21/23. Say what I want and should, but all the world can and say it all wrong and warped. Say what I want and should, but all the world can and say it all wrong and warped. That's a weird sentence. But we know Sarah likes to blow our minds with the knowledge bombs, the truth bombs, and the, the big words that she uses. All right, so why won't my attorney? So now, n- before it was, why can't I? Now it's, why won't my attorney do these things? Give me an honest answer. Show me everything she says she has and finished reviewing for my case, but withholds from me after I ask repeatedly for and about. Man, these run on sentences with the for and about and the hard read. But I get that she wants to know a lot about her case, but it probably is too much. It's like she's trying to control the case too much with her lawyers, and that's probably why they're butting heads. Because a lawyer, and if they know she's guilty and she wants them to plead not guilty or whatever, like try to lie for her in some fashion, then they're not going to want to do that ethically either. So she could put them in a difficult spot by um, maybe exposing some things that we don't know about the case. Anyways, so she also wants to know, why can't her lawyer give me an answer other than I'm putting this to rest, that's not necessary, or I'm not having this conversation with you? Well, now we understand. And now we kind of get it. We kind of get it. After a 58-page letter was just sent to the judge, I get it. Her attorney doesn't want to hear all the ideas that Sarah has because Sarah's got a lot of ideas and opinions, and she lets people know. So the best thing for her client is to let her basically tell her, shut up. I got this. We're going to focus on this. We're not going to talk about that because that's not important right now. What's important is this. She seems like someone you need to get to focus one way, and that's probably what's happening here. It's like Sarah wants to know, she has like 100 questions for each 5-minute phone call with her lawyer, and they're probably all over the place, scattered, in my opinion. And it would be very frustrating and difficult to have a conversation with a client like this, I think. And that's evident in the, well, that's not necessary. I'm putting this to rest, or I'm not having this conversation with you. Anyways, I'm sorry. Sarah, we love you. The nation loves you, loves to hate you, whatever it may be. I have no ill will towards you. If you are a victim of female or of ABUSC from your boyfriend, girl, I get it. But just stop talking. Stop talking. Stop writing letters. It's not helping your case. Anyways, all right. So, like, why can't Sarah's lawyers grant me access to anything I ask her for in and about my case? Why can't the lawyer, like the detective in my case, stop putting words in my mouth? Um, Tell me what's going on in my case. It's been well over 100 days. She has been my attorney, and I still do not know ongoing 5 years. Answer any of my questions, ever ask me any questions. How can she supposedly know everything she needs to know from what she's been told, heard, read, seen? So I get that, but She's not explaining that she hasn't seen her. So she's just saying her attorney's getting all of her information from the media, basically. Why can't her attorney reassure her that she's on her side for me, not against me? Why have I already been judged in the court of public opinion? Where'd it go? Oh, how did that happen? Well, it happened because we saw the body cam and the interrogations. And the whole time you were like, it's not my fault. It's not my fault. She's very defensive in her interrogations. All right, so why have I been sentenced by anticipation and condemned before my predicted trial? Yeah, I agree. Why does my attorney and all the world think my case is already over? Your Honor, during our first introduction and my last withdrawal of court appointed attorney number 7, Hobson, you stated to me your uninvolvement, sorry, it's hard to read her handwriting, your uninvolvement with any of my letters I write. You stated to me your uninvolvement with any of the letters that I write. I am still going to write my letters as, what does that say? I don't know. Continually? Conductively? What is that word? I have no idea. I can't read that word. Okay. Um, they are to the world where all my potential jurors are located, and this is the only way anyone, including yourself, knows the very necessary insight to my continued disadvantages, hindrances, impediments I am still experiencing on top of the new spurring my intentions to write. Okay. So she's doing it for the fans, guys. She's doing it for us. She wants the world to know what's going on. Continually? No, I have no idea what this word right here. Conduitely? I have no idea. Okay, moving on. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when the news cameras are off and we're all in between my status hearings. Two, as so many of the advantageous embezzlers, racketeers, mindless lemmings, and just altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people and being said incredibly incorrectly. So can I? Or so can I? Okay, Sarah, like I said, I got no ill will. I totally believe in innocent until proven guilty. I would definitely, um, I would agree that probably her situation is not ideal. It's public. Her stuff's on on the internet. It's really hard to overcome some of the things that are in her case. So, yeah, maybe a public defense attorney isn't going to put in a whole lot of time, especially knowing that she might be a difficult person. So maybe let the lawyer, back up a little bit. Let the lawyer take the wheels because that's what they're there for, and hopefully get you the best deal possible or something because coming out and speaking constantly is not the best idea. And it just hurts you more than anything. I guarantee these letters will be admitted as evidence. All right, so in her trial. All right, so as the compelling, annoyed detectives in my case, Copsol? I don't know. Co Copsol had to falsify documents, and Lowen wore his gun for me to see. I am sure you are familiar with after watching all my plastered, highly misconstrued, over 30 plus million views just on one site interviews, and yeah, she puts those in quotes because they were interrogations, and in which they both repeatedly attempted to, quote, feed me their incorrect, incomplete, hypothesized opinion by stating to me everyone has their limits at this seemingly endless point of perpetuity. Perpetuality. Perpetuality? Wait, what? Okay, I don't know. She just likes to throw in big words here. I don't even know what she's saying. Everyone has their limits. At this seemingly endless point of perpetuality of nonsense and lawlessness still growing, and I very much want to advance to the next level after ongoing 5 years now, a genuine concerned limit has been reached. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose to the internet, increasing the mass infection and destruction of my hopes to have a fair trial, anything fair, my side foremost, and wondering now if my attorney, quote, drank the punch like everyone else. So she thinks everyone is a conspiracy, everyone's against her. Is that what I'm hearing? All aforementioned reasons, and so many more, for this letter to be written, hoping to deter some of the unfair, one sided finger pointing it, and corruption and malpractice being directed at me only by those in the justice system who are trying to deflect the shame and shock from me fearlessly challenging the status quo, and it must be so because it's in my face on the computer at the same time on my boob tube television, brainwashed, ignorant followers of disbelief, conformity, and greed trying unsuccessfully to make my life by character assassination seem worse than theirs. Or maybe we just find you interesting because you keep the content coming. And it's interesting to read these letters. Like, what the hell did I just read in this paragraph? I don't know, but it was very interesting and I enjoyed it very much. I mean, she's entertaining at least. And I'm not like saying it in a mean way. I just, I don't want to be mean. And this channel isn't about meanness, but it is kind of like taking shots at her is easy because I'm not trying to take shots at her, but she keeps coming with things like this. The conformity and greed, the disbelief, trying unsuccessfully to make my life by character assassination seem worse than theirs. Like she's so dramatic in how she writes too, and I love it. I find it interesting. I find people interesting, and I like to learn and observe how people behave. So that's all. That's what I'm doing. And I also, I am looking at it from I don't want to use that term because it's an old term, but the battered women's syndrome or battered wife syndrome. She claims that, they were in a ABUSIVE relationship. I don't even know if spelling it helps. Please don't strike my video, YouTube. I really try not to say the bad words, but anyways. Um, so she says that she claims that that's the kind of relationship that they were in, and I want to take her, you know, um, word. I can give her the benefit of the doubt and see if there is more to the relationship. Maybe there is some evidence that he was physically hurting her and she somehow got him in there to like keep him away from her. I don't know. I don't know what the excuses could be or whatever, but I mean, I'm willing to sit through a trial and listen to it and give her the benefit of the doubt. unlike a lot of people that have really assassinated her due to um, social media and having all of her interviews and everything out there. But I think I might go over her interviews and her in the body cam, but not from a perspective of, oh, she guilty. We're going to look at it as let's really look at it and analyze it from both sides. So I that's a plan. I'm going to do that. All right. So how many now that the Karen Reed trial is just about to wrap up, I've got time to get back to things that I really want to do. So, all right. So oh wait, not number. Um, seems worse than there's no two when anyone points their finger. One, it's impolite, and two, three point back at you. How many tried it to see? Haha. Okay. Put the stone down, as there will be no casting of anything today except maybe for the role of my part for all the pre-conclusioned documentaries and crystal ball real life stories of true crime incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened, and is going to futuristically futuristically think that about you or judge you, I guess. I don't know what she's saying. I remember 3 points, 3 point back. Soothsaying is not a real job. To sum it up, in the words of my attorney after I told her to to Google me, she stated there's a lot. To sum it up in the words of myself, the defendant stated to my attorney after she stated to me, where can I see? How much longer do I have to wait, or how many attorneys must be withdrawn for me to be included in my case and be included more than the world presently is? This is my case in every aspect. See all my aforementioned ongoing 5-year questions. I am still waiting on answers. Also, I want to make it known I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answers to my questions and beyond. The quote, retarded vicious circle, sorry, not my word, I'm repeating, should have said our word, vicious circle, we enter every time we meet is a waste of time. And I'm saying that being in jail with supposed endless amounts of time. I got of time. She's in endless amounts of time. How she treats me is extremely prejudiced, hostile, and unconcerned. She is very frustrating. Number one, she's very frustrating to talk or wait to back. What is that? To balk or defeat in an endeavor to induce feelings of insecurity, discouragement, and dissatisfaction in. And three, to bring to nothing. Okay, what? What is she saying? So much I presented. Whoops. I am so sorry. My dog. So I think we got a package delivered and the dog. Oh my God, that was so loud in my ear. I apologize. Sorry, guys. All right. One thing I can't control is when the dogs bark. And I try to stop it, but I can't always get to the mute button in time. A little butthead. All right. Sorry. Um, all right, so I gotta start here. So much I presented. Oh, she's so frustrating. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added quote, pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems, like everyone else, not to remember I am innocent until adjudged otherwise. She treats me as if I am not. After my introduction and explanation for with pretend judge in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming. She asks for a pretend judge in the room, like the attorney says there's a pretend judge in the room. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. I should not have to invent pretend judge in order to be, and am not at all wrong for wanting to be respected, no matter the outcome. I am innocent until adjudged otherwise. My attorney, everyone's should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically, and effortlessly. Well, they don't have to be all those things. They just have to really, give you the best defense that they can possibly do. So they don't actually have to be courteous. I mean, truthfully, they don't. I should feel secure, highly confident, proud in her representing my life. I do not and have said to her many times regarding her what monumental disbelief in me and my case, which I believe contributes greatly to her what her attitude, her imbecile attitude towards me. Is that imbecile? I don't know. That's my guess. Her handwriting is atrocious sometimes. All right, so I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorneys prior who bowed out ungracefully and crept away from the battlefield unsuccessful. It is a battlefield to deal with Sarah, apparently. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. Maybe so, but there's too much video footage now that's available that is out there, I think, that makes it hard for a defense attorney to overcome with the police interviews and the body cam and her video on her phone. That's pretty hard to overcome. I mean, I think that's the problem is all these defense attorneys are telling her your case is really difficult. We should plead out. And Sarah's like, oh, no, no, no. I don't want to do that. And I want a trial and I want this and I want this. It seems like she's very controlling just by the letters. This does not mean my case equals success and in more than one way. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen, what? I am not a M word. The justice system should equal fair, faith, trust, respect, innocent until and if adjudged otherwise. 3 point back. Sarah, 3 point back. Sarah Boone. Confused cat meme. Yes, thank you. I have no idea what? Okay, so now that was the end of that first letter, but this is attached. So this all went into one attachment. June 4th, 2024, video visit, 12 minutes. In addition to my previous letter intended for hand delivery on 6/7/2024 at my status hearing, today my attorney made a video visit to go over everything I've been asking her for and have also sent to her personally in two letters, 520 and 525, all of the public video visitation box where all of the public video visitation box where on both sides of me less than 5 inches away from my visit, other inmates were having their visits also. So, I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in depth private meetings regarding my entire criminal case on the visitation box where there is no privacy whatsoever and held in an open bay dorm with more than 62 other interested all ears inmates. I cannot fully, I mean, I get that she's high profile. So if other people were listening, I could get that and whatever. But I'm sure all the other people have similar situations and probably aren't paying all that much attention to her, to be frank. But I she has a right to a private meeting with her attorney. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me, I can listen or not, still going over speaking and not at all allowing me to respond. After repeating to her over and over and over while she's beginning to speak louder and over me still to please schedule an in person meeting where all can be discussed further privately with no success of being heard, I disconnected the visit telephonically. She uncooperatively, uncooperatively. She is impossible. See in previous see previous letter or ask her for a copy of the two I sent her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. My question, please. Who acts like that and still be able to call themselves professional? The visitation box is primarily for family and friends to connect, and if a must from an attorney, reminders, notices, quick questions are not high level confidential case information. Okay. So I guess mm, she just wants her confidentiality. That's all. She wants her privacy. And she doesn't have it in the bay, and everyone's all ears. She, like other former attorneys who always, always, always blame their dysfunctions on me, said, "You don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except that I want to and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years professional. After so long and in all the experience, common courtesy, customer service, and listening skills should have been acquired." And I just want to say, I wonder if Sarah basically like badgered them until they got to the point where they're just like, I can't anymore. And this is how I'm dealing with you. I'm going to be just curt and to the point and say, this is what I need you to do. This is what we're going to do. And not let her go on and on and on and try to control the situation, because I have a feeling she tries to control every single conversation that she's in. All right, so all attorneys, do you remember why you even wanted to be one? Remind yourself. No one listens, and it works in everyone's favor but mine that I am a M word stuck in jail so they can pin it on me. They're unintentional, or I'm sorry, uninterested, unmotivated, hopeless. They're going to believe me over her haughty attitude. Okay. I am not wrong for not thinking less of myself because everyone else has and does. This present this present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for and Malappointing, praying they don't withdraw. Sorry, this is just really bad writing and handwriting. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for and malappointing every or praying they don't withdraw. Okay. I have not fired any attorneys appointed in my case. From me expecting the highest equal standards possible for wanting to the absolute best outcome in my preposterous mismanaged case. And respecting myself is not an option, as both judges have now threatened me with from being outspoken and intelligent in all my observations of the ongoing ABUSC. I am and have experienced, I have no experiences from it always being the same. Blame Boone. I refuse to be moved in waiting respect. Wait, what? I refuse to be moved in wanting respect no matter who everyone thinks I am, clarity, inclusion, honesty, and professionalism. And another great reason not to have my case meetings on the public visitation box is my personal confidential inmate information, such as my visitation lists with names, etc., my interaction with inmates and officers, what I eat, when, and my personal jail calls also being thrown online for what? I hate to hate me more or try to get others to because I don't eat breakfast or because I know some Latin have short hair, my penmanship is nice, or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having the to fabricate. I'm her handwriting is mutate, splice, edit. Okay, that's it. Or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, mutate, splice, edit. The world apparently knows all. All right, then. What's next? How many times I go to the bathroom and what function I perform? No one knows anything, nor seems to want to, from being comfortable in their corruption and striving to be on top with ratings, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted, and poked fun at about me, it's all in my favor, proving myself right about all the mindless lemmings, shut ins, the justice system advantageously abusing and profiting from everything in my case before my trial and before I've seen. Please be sure to read my attachment for FRCP Rule 3.220E restricting disclosure. Am I the only one who thinks of these things? When can I win? In anything, it's coming. I am not the problem, and if anyone were to slip on my slides and have to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't knock it till you've tried it. 3 point back, race to the pulpit. Again, always, Sarah Boone. Alrighty then. Now she provides a little history lesson, or lesson in law, I should say. West's Florida statutes annotated Florida rules of criminal procedure 3.220. And this is for her discovery. All right, so a notice of discovery. After the filing of the charging document, a defendant may elect to participate in the discovery process provided by these rules, including the taking of discovery depositions by Filing with the court and serving on the prosecuting attorney a notice of discovery which shall bind both the prosecution and the defendant to all discovery procedures contained in these rules. B, and there's a star by it, prosecutor's discovery obligation. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permit to the defendant to inspect, copy, test, and photograph the following information and material within the state's possession or control: a list of the names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charged or any defense thereto, or to any similar fact evidence to be presented at trial under section 90 whatever. Okay. And B, the statement of any person whose name is furnished in compliance with preceding whatever. Okay, so the term statement or used herein includes a written statement made by the person and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written. Or why is she giving them this? The term statement is specifically intended to include all police and investigative reports of any kind prepared for or in connection with the case, but shall not include the notes from which those notes are compiled. So she doesn't have the statements, she doesn't have all the statements from the police. Any written or recorded statements and the substance or any oral statements made by the defendant, including a copy of any statements contained in police reports or report summaries, together with the name and address of each witness to the statements, any written or recorded statements and the substance of any oral statements by a co-defendant. E, those portions of recorded grand jury minutes and that contain testimony of the defendant. Okay, so she just keeps going on. Let's just read her highlighted portions. H, whether there has been any electronic surveillance, including wiretapping, at the premises of the defendant or of conversations to which the defendant was a party, and any documents relating hereto. She wants the videos. She wants the interviews with the police, with law enforcement. She wants the body cam. She wants all of that stuff. And if they're not handing that over, that is wrong because those are discoverable. Let's see if she starred anything else because I don't want to read through all of this. All right, defendant's obligation here. If a defendant elects to participate in discovery, either through filing the appropriate notice or by participating in any discovery process, including the taking of a discovery deposition, the following disclosures shall be made. A, within 15 days after receipt by the defendant of the discovery exhibit furnished by the prosecutor pursuant to subdivision B1A of this rule, the defendant shall furnish to the prosecution a written list of the names and addresses of all witnesses whom the defendant expects to call as witnesses at the trial or hearing. When the prosecutor subpoenas a witness whose name has been furnished by the defendant, except for trial subpoenas, the rules applicable to the taking of depositions shall apply. And B, within 15 days after receipt of the prosecution's discovery exhibit, the defendant shall serve a written discovery exhibit which shall disclose to and permit the prosecutor to inspect, copy, test, and photograph following information and material that is in the defendant's possession or control. Prosecutor should copy and test all the things. That's what she wants. She just wants like the video footage and stuff and the statements and everything. And I don't know why she's not getting that. Also, the prosecutor and the defendant shall perform their obligations under this rule in a manner mutually agreeable as ordered by the court. The filing of this motion for protective order by the prosecutor will automatically stay the times provided for in the subdivision. If a protective order is granted, the defendant may, within 2 days thereafter or at any time before the prosecutor furnishes the information or material that is the subject of the motion for protective order, withdraw the defendant's notice of discovery, and not be required to further reciprocal discovery. Say that again. If a protective order is granted, the defendant may furnish the information at any time that is subject to the motion. Okay, I don't know. That's difficult language to understand. The defendant may, within 2 days or at any time before the prosecutor furnishes the information or material of the motion for protective order, withdraw the defendant's notice of discovery. So at any time, they can withdraw the notice of discovery and not be required to furnish reciprocal discovery. Okay. E, restricting disclosure. The court on its own initiative or on motion of counsel shall deny or partially restrict disclosures authorized by this rule if it finds there is a substantial risk to any person of physical harm, intimidation, bribery, economic reprisals, or unnecessary annoyance or embarrassment resulting from the disclosure that outweighs any usefulness of the disclosure to either party. So there's something that might be embarrassing to her that she doesn't want out there. Is that what she's saying? All right, sanctions. If at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with the applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed or introducing in evidence the material not disclosed, or enter such or other order as it deems just under the circumstances. So the judge can put sanctions on whoever the party was that wasn't complying with the discovery rule. And one of those sanctions could just be like, well, that discovery doesn't come in, or that discovery may come in, but we're going to limit it to just a little bit, or whatever. So the court, I think she's highlighting this because she's saying, look, the court has the power to make the state turn this stuff over to me, and they're not turning it over, and I'm asking for my discovery. Also, B, not interposed for any improper use or purpose such as to harass or to cause unnecessary delay or needless increase in cost of litigation. So she's highlighting that, I guess, because she's like, my lawyer is unnecessarily dragging this shit along and I want it done. Um, which I get, and I bet she's frustrated having been through 8 lawyers at this point, but you know what? I guarantee some of it's her fault. Um, is that the end of that? What's the end of that? She's still quoting something here. Yeah, she's still quoting these things. Okay, now now she's got the American Declaration of Independence. I'm not gonna read it all, but there it is. There's the Florida Constitution. Yeah, yeah, yeah. Client. She gives us a definition of client: a person who relies on the professional services of another. The client of an attorney is the person or entity represented and advised by the attorney. A client relationship commences for an attorney with an agreement with the performance of service in reliance on a request for representation or with a statement of representation on which the client relies. All attorneys owe a client a duty of zealous representation, which they do, based on the obligation to serve justice and act as an officer of the court. Attorneys also have an obligation to keep the confidence of the client at all times and to keep the client informed of all matters related to the client's interests, to inform the client of law related to the client's affairs, and to defer to the client's decisions, although the attorney has no obligation to the client to perform or refrain from any act contrary to the highest standards of professional responsibility and to the law. All right. Attorney client privilege, one of the oldest recognized privileges for honest, equitable, confidential communications intended to encourage open, full, and frank communication between attorneys and their clients, thereby promoting broader, confident correspondence in accordance to the appropriate observance of law and the administration of justice. Do you see how much better I read it when it's words that like make sense together? All of her sentences are just like a bunch of rambles and they're not like full sentences. But when somebody else writes it and she's just repeating it down on the paper, I can read it. All right. Zealous advocacy. An attorney must represent each client to the fullest extent under the law and requires representation to the attorney's fullest abilities without violating the rules of professional responsibility. It requires not only presenting each argument required by a client to every institution in which that client has business, but also framing each argument in the strongest terms of law that greatly benefit the client while remaining faithful to the facts and to the law itself. I'm not gonna read all that. All right, so attorney misconduct. Oh, she's gonna sit here and say her current attorney is potentially committing some kind of misconduct. I mean, that's why she's got this highlighted here. Isn't this a great lesson in the law from Sarah Boone? Attorney misconduct is a failure of an attorney to comport with the rules and accepted professional customs of the bar and includes any act or omission of duty by an attorney that fails to perform appropriately the office of an attorney as an officer to the court, as a counselor and fiduciary at a client, or as a member of the legal profession. The scope of attorney misconduct reaches also to conduct of attorneys that is harmful to the appropriate reliance of the citizenry upon the law and legal profession. I don't know if that was her words or if she copied that from something, but that was bad. Attorney misconduct includes actions or omissions that enable others to cause harm, not just harm caused directly by the attorney, and not all misconduct is subject to remedy or to the sanctions, and although a variety of forms of each exist. Okay. Misconduct may always be the basis for a client to remove an attorney from their duty at representation, as is any other cause for the client's loss of trust and confidence in a lawyer, and the attorney's demeanor to determine whether a party's substantial rights were affected based on repeated or persistent objected to misconduct. Okay, blah, blah, blah. I'm not going to read all that. She's something else. All right, duress. An unlawful threat that limits the person's independence of judgment or action and is any improper threat or condition, such as coercion, that limits a person's ability to think or act independently and the presence of destroys the independence required of the party subject to. All right. Habeas corpus, great writ, a review of the lawfulness of any person's custody or restraint by a government official. So does she think she shouldn't be in prison right now? It is a process of judicial review of any person's detention, whether by formal custody, incarceration, or continuing restraint by an official or agent at the government, at the state, or the federal government. A defendant who has been confined for 30 days. Wait, why is my. Sorry about that. We got noisy dogs because they're happy their daddy's home. All right, so a defendant who has been confined for 30 days after their arrest without a trial shall be allowed a preliminary hearing upon application. Does she not have that? Is that what she's trying to point out? She never had a preliminary hearing? Informal consent, consent given with appropriate knowledge after the person giving consent has learned all of the information that would be reasonably required for the basis of a reasonable decision in many instances for an institution or professional to prove that the decision maker was sufficiently informed over a matter to give informed consent, the institution or professional will provide the information requisite to making such a decision in an informed way by the provision of the information. Okay. God, these really are just long, and I don't know why she gave them so much. And then here's legal ethics, the professional obligations of a lawyer, including those codified by rule and a body of rules and standards of conduct. Okay, so legal ethics, whatever. So she's saying maybe her lawyer doesn't abide by legal ethics. Is this a lesson in the law for her lawyer? Equal to protection of the law, each law should treat similarly situated individuals in a similar manner. Equal protection of the law is one manifestation of the ancient. So, like, all she's doing is reciting all this stuff. It's not like she's interpreting it. It's not like she's making any kind of argument. She's just writing all this down as and then starring sections that she thinks might apply to her. Abuse of process, a claim for harm from the misuse of of the legitimate legal process. This is the claim that can be brought when a pleading or procedure is wrongly employed for the purpose of harassing or injuring the opposite litigant. So she thinks that's happening to her in this case? I don't think so. Examples include filing a false affidavit. My arrest affidavit has someone else's information listed and also a N, no for domestic V, then sworn to be true and correct by Connolly. See the impeachment document. The lead detective in my case, what other discrepancies have been made in my case? Making false claims, see interrogation videos, introducing fraudulent evidence, statements, assumptions, guesses. So that's what she's going to say, that it's an abusive process. And that's what she's trying to use um, for her defense, I guess. Interrogation, examination of a suspect, this process of inquiry by which police or other law enforcement personnel seek information from a person suspected of a crime. Interrogation is distinct from interview, as titled on my transcripts, in that the police seek not merely information in general from the suspect, but also statements from the suspect that are either directly or indirectly incriminating. This may involve direct questioning or other actions. But I don't know how she didn't know that she was in an interrogation, but okay. So she's giving the differences between interrogation versus an interview. Because what's a custodial interrogation? That's an interrogation of a person in the custody of law enforcement officials. Yeah, okay. That's perfectly legit. She I don't know. Oh, what does it say? Freedom to leave. Huh. Okay, here we go. Let's read this. Interrogation of a person in the custody of law enforcement officials and is following a person's arrest or custody. The hallmark of custodial interrogation is that the person knows that the person is in custody and has no freedom to leave. I did not know I was in custody and could not leave. I was told by Keepsel to come, or Coopsel, I don't know, to pick up my phone. No, no warning of being interrogated again. During custodial interrogation, the stakes of interrogation are higher than when a person is free to go, and any statement made in custody during is presumed to be coerced under the Fifth Amendment. I don't know about that, but I see what she's going with that with that argument. An excited utterance is spontaneous declaration or spontaneous exclamation. Is she saying that that's what she had was an excited utterance because she was in duress that day? I think that's what she's trying to claim. Why is she giving us maps now? Oh, this woman. Okay, publicity, exploitation, and saturation. United States map 1. To date, each is a state where I have received correspondence via mail or message regarding my current criminal case. Okay, world map 2. To date, each star is a continent where I have received correspondence via mail or message regarding my criminal case. Who cares? The number grows daily. So she's getting emails or correspondences from people all over the world. Most most all letters and messages are available for review and understanding of the impact of my case, details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. I, the defendant in my case, have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. The constitution of the obvious exploitation allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. My present attorney said it is not necessary to receive a court order. I've been trying to obtain to download my case information to apply from the OCCD tablets. So the tablets that they get when they're incarcerated. She can't view anything unless she can get it downloaded, I guess, onto her tablet. My former attorneys are withholding some of my case contents I have supplied to them and which have been deemed lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unable to be located to date. I am missing innumerable case items which I continually request to be returned or obtained without success. Invasion of privacy, Supreme Court, wrongful conduct, appropriation, the unlawful use of a person's name or likeness to obtain some benefit. What? Intrusion, physically or electronically intruding in one's private quarters. No one's intruding on her. Public disclosure. Oh, here, defame. That's the one that starred. Sorry. Okay, she's unhappy that everyone out there is defaming her. To injure or destroy the reputation of by libel or slander, anything is defamatory if it has the tendency to render the party about whom it is published contemptible or ridiculous in public estimation, or expose them to public hatred or contempt, or hinder virtuous men from associating with him. What? An opinion can be actionable if it implies the allegation of undisclosed defamatory facts as the basis for the opinion. False light. I don't know why she's now we're back to lessons. Publicity, exploitation, and saturation. My personal individual criminal case is being advantageously exploited and abused from all of my significant life saving, suppressible case details, evidence, proof being illegally obtained by coercion, trickery, duress, confusion, and without my permission in any form, with written or verbal, to anyone, then broadcasted, distributed, hand delivered to the entire planet, states, countries, continents, containing all of my potential jurors, causing irreparable, erroneous falseness, greatly tainting my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, ideas. That was all like one sentence. Okay. Alrighty. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion of my case. A misprejudgment has already been made unfairly against me from the undeniable violations of my constitutional rights and due process of law as a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully, ethically, should be without disadvantage and free from all partiality, deceitfulness, dishonesty made from said evident exploitation. And now she's citing her sources. She's giving us ex- the definitions of certain words: exploit, exploitation, abuse, significant, suppress. Oh God, these are all the words that were in her sentence or in that big long sentence. See? So everything that she highlighted here, or underlined, I should say, everything that she underlined as exploited, abused, significant, suppressible, all these words that are highlighted, she's going to now define so that us dumb people who don't know what they mean, we can look and look up the definition of all those words so that we can understand Sarah Boone better. Because that's the problem. We don't understand her enough because we didn't have the right dictionary. We didn't have the right dictionary. This is all, I'm just still scrolling. Um, there's so much to it. I'm not even going to read it. But obviously, if you guys want to, I will try to find a link that I can send to you, or not send to you, put it in my, put it in the description below. Now she's highlighting the words coercion. So she was coerced, I guess, in her confessions. Freedom of Information Act. So now she's giving the lawyers a law on the Freedom of Information Act. And that's it. Finally. Oh, finally. I got sick of scrolling. I bet her hand hurt worse after writing this 58-page document because, oh my goodness. And thank goodness I didn't have to read all of it. All of that. All of those legal definitions. Yeah, no. Why would she write all of that in there? I don't know. I don't get it. I guess she's trying to make her own legal arguments for herself. She should just be her own lawyer if that's what she wants. But she needs a lawyer. She obviously needs a lawyer. And I don't recommend that she should do it herself. But seems like that's potentially the way it's going to go because I think the judge said in the latest hearing, like, you either work with her or you don't get a lawyer. And, like, we're going to trial no matter what. So, um, I don't think the judge is going to do anything about it. I do expect more letters from Sarah, and I do expect her to be trying to get rid of this lawyer some more, but we shall see. Hopefully they can come together on some kind of agreement and work together because I believe they have a trial date set, don't they? I don't remember, and I'm not gonna look it up right now. But yeah, I thought they had a trial date set, or at least I thought that the um the judge said that he was moving forward regardless with time frame of whatever. He didn't want all these lawyer changes to be delaying the case. He wanted to move forward. So we shall see. Please hit the like button and the subscribe to make sure that you get notifications when I have more videos about Sarah Boone. I hope to see you guys in another video. Thank you so much for watching. Take care. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.